Okay, we're going to go ahead and get started. Appreciate everybody for joining us today. I know it's Friday of a long weekend during recess, so we do appreciate everybody who took time to join this briefing today. My name is Jen Olson. I'm with the Alliance for New Immigration Consensus. And this is a briefing series that the ANIC, as we like to call it, is launching. This is our first. And just a brief background on the ANIC. We're a group of business representatives from the faith community, the ag community, national security, and education communities who've all come together around securing the border and fixing our broken immigration system. This briefing series, though, is really aimed at short educational seminars for Hill staff and others interested. We're going to try to keep these to 30 minutes with two noted experts for each topic area. And we would love to answer any questions that you have. You can use the Q&A function to type in your question, and we will get to those at the end. But again, these are aimed at being short informational sessions. We will record them and keep them on the ANIC website as well, so that they can be accessed by others. Before we start today's program, I just want to flag the upcoming forums that we have. We will have a briefing next week on unaccompanied children and why they're coming and how they come and what happens once they enter the United States. And then the following week, we will also be looking at the numbers at the border and what is happening, what are the trends that we're seeing. And following that, we will be doing one on immigration backlogs, so processing and court backlogs, and understanding the underlying issues there. But today, we're thrilled to have two noted experts who are no stranger to many of you on the Hill, John Baselice from the U.S. Chamber of Commerce and Laura Reiff with the Essential Worker Immigration Coalition. We'll talk about work authorization for non-citizens. Who has work authorization? How do they get it? With that, I will turn the screen over to them. And again, if you do have questions, feel free to just type them in the Q&A button and we will get to those when they're done. Without further ado, Laura and John, take it away.
Thank you, Jen. For those of you who don't know me, I'm John Baselice. I am the Vice President of Immigration Policy here at the U.S. Chamber of Commerce with my friend, Laura Reiff, who is a partner at Greenberg Traurig. And in terms of the basics of employment authorization, who gets it, how do they get it, it's best to understand the few basic fundamentals of U.S. immigration law. So how does one get employment authorization? Well, one, there are employment-based immigrant visa categories. There are also employment-based non-immigrant visa categories where the work authorization is tied to the reason that the individual is coming to the U.S. in the first place. This could be someone who's an H-1B at a tech firm. It could be an H-2A worker at a farm somewhere in the Midwest or in the Southeast or out West. It could be a crab picker or a landscaper or someone who was working at a seasonal hotel on H-2Bs. It could also be an intercompany transfer in the L program. And there's many other categories that are basically, it's tied to the work authorization is tied to the reason that the individual is coming. There's also the family-based immigration system where there are various types of work authorization options for individuals, whether they're an immediate relative of a U.S. citizen or they're coming to the U.S. under one of the family-based preference categories 1 through 4. There are also other humanitarian options for folks who are refugees and asylees. There are rules tied to when can the individual apply, when can the individual actually receive the work permit. And it kind of is a little bit of an issue, particularly when the individual gets here, where they can't just work legally right away. And last, but certainly not least, there are other executive branch programs, thinking the Cuban, Haitian, Nicaraguan, Venezuelan parole program, the DACA program, and other historical uses of deferred and forced departure, and other tools where folks who may not have been legally admitted to the U.S., but are nevertheless allowed to apply for work authorization because we're letting them stay in the country pending their cases. Those are the basics in a nutshell. Laura, why don't we start with the employment-based immigrant and non-immigrant categories and how work authorization works for those?
Great. Thank you, John. And thanks, Jen, for having us. Many employers are looking for folks who can work in the United States. And a lot of times you get applications from individuals who are not US workers, meaning they're not permanent residents or US citizens here in the United States. And so we get calls, John and I get calls all the time saying, well, what can we do? How can we hire them? Well, there's a finite group of visas for companies to sponsor individuals. And that finite group of visas hasn't changed in 3 decades. So it's a little problematic and you have to be a bit creative. You definitely should talk to somebody who knows what they're doing when it comes to immigration. But let's talk about kind of the alphabet soup. John alluded to the L1 visa. So if you are working for, if you're a company in the United States and you have an entity that's outside the United States and the individual has actually worked for that entity, you might want to look at what's called an L1 intra-company transfer visa. If an individual has worked overseas for at least 1 year for a related entity to the entity in the United States in an either specialized knowledge, managerial, or executive capacity, that individual might be able to come to the United States as an intercompany transfer. That's an L1 visa. The application is usually filed with Homeland Security. And if the person's approved, they can come in for either 5 or up to 7 years. So that's one way. Not many companies, though, have broad reach like that. I know the Chamber represents a lot of small businesses and they don't necessarily have operations overseas. So what if you're a small construction company and you want to hire somebody in either, let's say, a financial analyst role or in a construction capacity? How would you do that? So one visa type that John mentioned is the H-1B visa. That's the specialty occupation, or what we call professional visa. If you have an individual who is a foreign national who has the equivalent of a US degree, whether it's undergraduate or graduate degree, they may qualify for this H-1B visa. Unfortunately, there are limitations on the H-1B visa. There are only 65,000 visas for the bachelor's degree category and an extra 20,000 for people who have a master's or PhD. Those visas run out very quickly because that's a total of 85,000 visas. So there is a lottery for those visas every year, or what they call an H-1B registry. So if you have somebody that you want to hire now, you have to wait till the registry for the H-1B, let's say that financial analyst that we were talking about, register that particular candidate in March. The drawing will be in June. If the person is picked, there's about a 27 to 30% chance of being picked, depending on how many people go in to the lottery. Then you will be able to start in October of the next year. So it's a long wait time, but there are many companies that are willing and able to go through that. Obviously, if we had immigration reform, we would change those caps. But the H-1B specialty occupation visa is one. If the individual actually has a current H-1B visa and you want to hire them, you could move them from one H-1B employer to another. There are some exemptions to the H-1B limitations. If you're from Chile or Singapore, we have an agreement with Chile, with the government of Chile and Singapore, so there are an extra 6,800 in visas for H-1Bs. So H-1B is one category. What about that construction worker? There's really not a year-round visa for a lesser skilled worker. You might want to look at H-2B if it's a seasonal or peak load visa, or seasonal or peak load need. But H-2B visas are an option if you do have a seasonal or peak peak load short-term need. You would have to go to the Department of Labor, you'd have to test the labor market, and chances are you're not going to find a US worker who wants that job, and then go to the USCIS for approval. Again, there are limitations on the numbers of H-2B visas, but that's one route you could take for a lesser skilled worker. Again, there is no set visa for a year-round lesser skilled worker. John and I have been working on cracking that nut for a long time. Another visa type is the North American Free Trade Agreement, which is now USMCA, or the TN visa that was started in 1990. So if you have somebody who is Canadian or Mexican and they meet the schedule that was adopted in 1990, there's a professional schedule, then you potentially could bring in engineers, doctors, nurses, accountants, economists from either Canada or Mexico, but they must be Canadian or Mexican passport holders. They can't just be living in Canada or Mexico. One other type of visa, part of this alphabet soup, it was negotiated through a treaty, is the E3 visa, which is for Australian nationals. And if you have an Australian national and they're coming to the United States to perform highly skilled, more like H-1B work, the E3 is a way to go. A lot of folks will find that they have in their employ foreign students. These are the F or J students who come to the United States to study, and they get what's called either curricular practical training or optional practical training. Those foreign students can work for a limited period of time in the United States with the appropriate authorization, and then many of those will want you to sponsor them as their employer to move from F1 or J1 status over to H1 status. But a lot of times your F and J students will have a significant amount of time. Sometimes if they're STEM, science, technology, engineering, or math designees, if they're studying in that area, they could get up to 3 years of work authorization. So John, those are kind of the top level visas, non-immigrant visas, where an employer could actually sponsor an individual to come and work for them. And those, again, are non-immigrant visas. I don't know if you want to talk about the green card process a little bit. That's a lot longer process. If you want to sponsor somebody for permanent residence, it could take up to 2 to 3 years. But for immediate needs, you're going to want to look at the non-immigrant visa categories.
Thank you, Laura. And just a few things I want to add, because I know we are now at the halfway point in terms of what we're trying to keep this to a half hour. But the green card process that Laura described, it entails a lot of prevailing wage determination work that has to be done by the company. You then have to get a permanent labor certification to basically say, hey, by hiring this individual, I am not harming any similarly situated American worker who may want this job. And then you need to go through the process of filing for the green card. Typically, if you're applying for someone who is an Indian national or a Chinese national, there is a backlog waiting for them. So not only do they get told, hey, you are eligible for this green card that you want, however, you're not going to get it because there's thousands of people in front of you that are looking for these green cards too. And it's important to know this, not to get back to some of the options that Laura discussed, particularly H-2A and H-2B. Those programs also have a labor certification component to it. So if you're looking to hire those individuals, it's not just a matter of, hey, I can go to DHS and say, hey, I need someone for this particular job, let me apply. Your first step is to go to DOL and say, look, I have a need for these workers, I cannot find them. You have something similar with H-1B. It's not necessarily a full labor certification, but you need to file a labor condition application when you do this. So there's a lot of work, and some of these programs that Laura discussed, we didn't get into the E1s and the E2s, which are countries where we have a treaty of friendship, commerce, and navigation. There is no Labor Department component with those types of programs because the way that Congress designed those particular programs, it's trying to be able to facilitate talent moving from our trade friends here and there. So typically there's a reciprocity of treatment. We treat their nationals very kindly when they want to come here. They treat Americans when they want to go abroad to work similarly. Laura, why don't we skip ahead to the family-based programs, whether it's immediate relative or a family-based preference 1 through 4. What entails individuals coming into the country in those particular categories to be able to get a work permit?
Right. So we do have a family side of the immigrant visa categories. If you are married to a US citizen, that's the highest category. That's an immediate relative category. Or if you have your parents you're a US citizen and your parents want to come to the United States and they're outside the US and not US citizens now, they're considered immediate relatives. Now, immediate relative is not the appropriate connotation because it's not an immediate work permit. There are filings that have to be done, immigrant visa petitions that have to be filed, and then a lot of background checks that have to be done. If your immediate relative who is in the middle of sponsorship is here in the United States, you can file a petition for an adjustment of status and an immigrant visa petition together, and it will probably take between 4 and 6 months for that individual to get a work permit. If they're outside of the United States, it can take 2 to 3 years for that person to actually get a work permit. Some of the other categories, if you're a permanent resident of the United States and you are sponsoring family members outside the United States, John mentioned the backlogs and the immigrant visa numbers. It can take years before you're even eligible to petition for the individual to go to the US consulate or embassy abroad and get that immigrant visa and come to the United States. So that's kind of a long game unless there's an immediate relative petition filed. But it is an option. And that's another reason why when you are looking at how am I going to hire this person who is great and is going to be perfect for me and they're from Costa Rica, you want to have somebody analyze all different options. Do they have parents here who are US citizens? Do they have children who are US citizens? Do they have were they born in another country? Were they born in Singapore? Were they born in a country where there's a treaty with the United States? Is there a way that they can get a student work authorization? So you want to be creative because we don't have kind of normal channels you would think of going through. So family-based categories are probably not going to be the easiest way to get your worker here if you're a business. And neither are employment-based green cards. It just takes too long because of administrative processing and the backlogs.
And Laura, to add on to your points, in terms of how the employer sees it, because from the perspective of my members and Laura's clients, when they're hiring someone, all they are given when they're doing the I-9 process, which is the process by which the company must verify the individual's identity and whether or not they have work authorization in the US. They give us the forms of identification that are laid out by the federal government, one for identity, one for work authorization. And oftentimes you'll get someone who has, whether it's a passport or not necessarily a US passport, a foreign passport that's identity, or they have a driver's license because they lived here, and then they have a work permit. More often than not, unless the employee or the prospective employee divulges what type of status they are in to the company, they're under no obligation to do that. So the company oftentimes, even large multinationals with the most sophisticated HR departments you could imagine, they don't know what status that individual is in. But the key thing to understand is there's a lot of family-based preference immigrants, a lot of immediate relatives who are still working legally in the US. So while oftentimes you'll see the business community really get up in arms when we hear members of Congress wanting to cut immigration, particularly if it's in the employment-based categories, because those are folks that our members and Laura's clients are actively recruiting. When you cut family-based immigration, you're also cutting off a source of a labor source for us. Like that's a talent pipeline. While it might not be designed strictly for employment-based purposes, a lot of our companies hire individuals that are coming to the country or have come to the country under those channels. And I think it's important to understand the same type of issues happen when we're talking about asylees and refugees. This is an
Yeah,
issue
I
where
kind of want to get into those programs,
yes,
John. You just touched on, there are millions of people in the United States right now who are on US payrolls, who are in a precarious status. They may be in an illegal status. They may be fully work authorized. And that's kind of the bucket that John and I have been alluding to, of humanitarian programs, people who have sought refuge here, people who are seeking asylum here, people who may be illegal and may be able to provide some of those documents, whether they're fraudulent or not, to show that they are lawfully authorized to work in the United States. But what are some of those programs that we're talking about, John, that have popped up just in the last couple of years, or even been given kind of higher prominence, like DACA? You mentioned CHMV, the Cuba, Haiti, Nicaragua, Venezuela program, but there are literally millions of people here who are in one of these humanitarian programs.
yeah.
So
And
you
the
want to
thing
talk
is,
about CHMV?
yes, and the key for us is we don't know when someone's in this status, because if they have been given the AOK to enter and they are allowed to apply for a work permit, not wanting to jump around from asylum to CHNV and people using the CBP One app, but this was an issue that lots of folks who came as asylees or putative asylees are still waiting to see whether or not they actually get the golden ticket at the end of that rainbow. They have to wait at least 6 months to get a work permit. And when you compare this to other countries, particularly in the Eurozone, 6 months is a common wait time. I think the UK is 12 months. I know Germany, before they passed their reforms, which I think brought it down to 6 months, it used to be 2 years. And, not to take this conversation a little far afield from where we're at, but it's really important to know that if folks are asylees and they aren't allowed to work, it doesn't allow these individuals to really get an understanding of the culture of their host country. You used to see all these stories of these ethnic ghettos where really bad things would happen, and making sure that folks actually get into the workforce, they start to realize what life in America is like. So getting them into the workforce is a good thing. And
and we
the other
have,
thing is, in those European countries, the reason why they made these changes, it was a drain on their welfare system, because they wouldn't allow you to work. They'd have to give these folks some sort of support to survive in the host country while they wait to be able to apply for a work permit. Laura, you were
but
saying.
many employers are saying that they want to help sponsor some of these people in humanitarian programs. And there are many ways to do that through the Ukrainian humanitarian parole program, the Afghan humanitarian parole program, the Cuba, Haiti, Nicaragua, Venezuela parole program, which allows 30,000 people a month to come in. Although there are some issues with those programs. The individual comes in, if they actually are chosen, they work for 2 years, and then what happens? So there are a lot of people here who are work authorized, and it may be very temporary, like DACA, like humanitarian parole, like TPS, but they are authorized to work, and you all should know about that. I see Jen popped in because I think we have a question.
We do. We have about 5 minutes remaining. We do have one question. Encourage others who may have questions to just type them in, and we'll get to everyone's question. But here is one from an attendee. A huge takeaway here is this is a convoluted process. What is the effect of all the crazy bureaucracy, and would Americans benefit from the process being streamlined?
Well, Mr. and Mrs. Anonymous, it's a fantastic question. Yes, people would benefit from the process being streamlined. But getting back to some of the things that Laura was talking about in terms of not just the labor certification that needs to happen, the quotas are a huge problem in how they're constructed, because they're basically ossified. They are frozen in time, and there's no getting around them. So even if you could speed up the process of all the stuff, like, hey, we're going to do all the paperwork more quickly, you're still looking at a situation where in H-1B, I think for every 6 individuals seeking an H-1B visa, or every 6 applicants being sought by U.S. companies, only 1 is getting a visa. In the H-2B context, if we were still operating under the 66,000 quota, you'd basically that ratio would be 4 to 1. So 4 folks being sought, 1 person getting a visa. Thanks to all of you who are really active on the H-2B cap relief measures that have happened for the past several years in the PROPs, because you've brought that ratio from 4 to 1 to 2 to 1. That's helped a lot of folks out. But at the end of the day, it's still, for every 2 people being sought, only 1's getting in. And you look at the green card categories, whether it's employment-based or family-based. I mean, you can look at the Indians waiting in EB3. You can look at the Philippine nationals that are waiting in family-based preference 4. It's sad to say, but it's the truth. A lot of these folks are going to die waiting in line.
Well, that's true. And streamlining is one thing. We have multiple agencies doing a lot of the same things. We should streamline them through maybe one central agency, DOL, Department of State, Department of Homeland Security. But we also have a way outdated immigration system that dates back to 1986, 1990, that just can't keep up with current needs. I mean, it's sinful, honestly, that the TN category, USMCA, has a list of professional categories that were promulgated in 1990. Things have changed a lot. I mean,
Yeah.
a whole lot. So updating, streamlining, and basically reforming our immigration system, which ANIC and EWIC and the Chamber have been trying to do for decades, is something that everybody should jump on the bandwagon for.
And Laura, not to put too fine a point on it, but you look at the quotas, you look at the rules, you look at the regulations. All of this stuff was created prior to the internet being a thing. Like in 1990, I remember going to my dad's office in 1990. He had his IBM PS1 with a 25 hertz processor and a 20 megabyte hard drive with the 5 1/4, not even 3 1/2, the 5 1/4 discs, and his fax machine. Modern businesses don't run on this anymore, but our immigration system still acts like it does. Our economy is literally 4 times the size it was the last time our immigration system was really reformed. It's long overdue.
Yep. There are ways to do this legally and get people on your work, in your workforce legally, but you kind of have to know how to make your way around an archaic system, and it shouldn't be that archaic.
And one thing to add about the CHNV parole program, having been in the Rubio office during 2013 when we were working on S-744. The Biden administration did this on their own. Said, listen, we're going to allow 30,000 people to come per month from these 4 countries. In S-744, this was March, April 2013. We were working with organized labor. They wouldn't allow us to have a program that would have more than 20,000 non-seasonal blue-collar workers coming in a given year. Now, if you waited throughout it was 20,000 year 1, I think it was 35,000 the second year, 55, and then we finally get into the formula that yours truly and some other folks who they'll remain nameless for this call, but happy to tell you if you want to go out and get some drinks sometime who all made this formula. But once you got there, it was going to get to about maybe 150, 180,000 a year. But when it's 30,000 a month compared to 20,000 the first year, like it's interesting to see how far folks have come and realized, look, we really need to start getting serious about this. Now, I will preface all that by saying I have yet to have one member who has had an awful lot of success trying to use a CHNV program or any of the other humanitarian parole programs to actually find workers. everybody that I know that has tried has been like, I've spent a lot of time, effort, and money, and I've gotten very little for it.
I think the
And-
Ukrainian humanitarian parole program is probably the one exception because they have streamlined that. But generally speaking, I would agree, none of my employers have really had any success. And they're now, once you do get CHMV, if you are lucky enough to come into the United States under that particular parole program, they have already said that they're not going to extend it. So you have to find another way to stay here, whether it's applying for asylum or, you know, if you've been designated for temporary protected status. So yes, those programs are precarious.
Yes, and Laura, to also add to the precarious nature of all these things, you look at DACA, you look at CHNV, there are lawsuits challenging the legality of them. That's another reason why companies typically are a little hesitant to look at them and say, hey, we'll look at this as a means to try to meet our workforce needs. But getting back to the other point that I made, when a company is doing the employment verification, doing their employment verification processes, I should say, they can't tell if they got CHNV or DACA on their own. They can't tell that individual has that unless that putative employee tells them, hey, I am in this status.
And I think we're at a half an hour. So again, huge thank you to Laura and to John, and to all of you for joining us today. We will send out a follow-up note to everyone who RSVP'd, just with email addresses. Feel free to contact me or Laura or John if you have any additional questions. More than happy to dive in more deeply on any of the issues that they raised. But again, thank you for your time on Friday afternoon, and hope everybody has an excellent weekend. Thanks again.
Bye,
Jen, thanks for
everybody.
having me.
Thanks. Bye.